Now, very shortly, the agenda for today is going to be learning about trial advocacy. The gentleman you see across your screen, Mr. Vivek Khemka, is one of the top commercial lawyers. He has an expertise in arbitration also, and he also is a masterclass on trial advocacy. So हमारा plan कुछ इस तरीके से है that we'll try to unwrap some of the very essential skills of trial advocacy. That is where everything starts from. High Court, Supreme Court, appellate courts, all these are glamorous, but whatever glamour comes to it comes from the foundation which is called the trial advocacy, जिनको हम पहले लोअर कोर्ट्स कहते थे, आज लोअर कोर्ट्स नहीं कहते हैं, अब हम ट्रायल कोर्ट के नाम से जानते हैं उसे. So that is what we are going to focus on, and along with that, there's going to be a little tinkering that sir wanted to introduce कि आप एडवोकेसी स्किल्स, ट्रायल एडवोकेसी स्किल्स को आर्बिट्रेशन में किस तरह से इस्तेमाल कर सकते हैं. दैट अगेन इज समथिंग वेरी इंटरेस्टिंग. एंड जैसे हम सबको पता है, आर्बिट्रेशन अगेन इज समथिंग वेरी ग्लैमरस, समथिंग दैट पीपल आर trying to pursue. So why not pursue it well, right? So let's learn from sir, and I'll give away the stage to sir. बस उससे पहले एक चीज, please do not use your mics unjustly. You have your access to mics, but only use it for the Q&A session that will happen at the end of the session. Beach mein we will try not to ask questions unless and until the trainer asks us to ask questions. So do not jump in, do not cut in between, and please stay on videos. Keep using your chat. I'll be looking at it. My team is there, and हमें questions मिलते रहेंगे, and अब आपके questions के answers आपको मिल जाएंगे. Right? So we can start.
Okay. So good afternoon, everybody. How many people are lawyers over here?
Almost 70% of the class, sir.
All are lawyers. And most of them seems to be much senior than me. So whom should I teach? I should learn from them, I think so. Rajesh Tandonji. So all are from the trial court? Most of the lawyers are practicing in the trial court?
So I am actually practicing in Armed Forces Tribunal.
Oh.
Delhi High Court.
So you should be given a salute. Just independently clear. Achha. So see, arbitration is actually similar to a trial court. There is no difference between trial court and arbitration. Only thing is the invocation powers are little different compared to civil court. In civil court, you file a suit, you pay court fees, and then the basic procedure starts as per CPC. Same thing happens in arbitration. In arbitration, you send a section 21 notice. Like as you file a suit in a trial court, you send a section 21 notice. So that's the starting point. You send a notice, mention your claims, and then you say, I'm invoking arbitration. So it is as good as you're filing a suit in the trial court. On the basis of those claims made, if the other side doesn't agree for a particular arbitrator, then you file a section 11. Just note down this. Sections are very crucial in arbitrations. So the person doesn't agree to a particular arbitrator, so you file a section 11 petition in the High Court that I have invoked arbitration under 21 and other side is not agreeable for a particular arbitrator. So High Court then intervenes and appoints an arbitrator. It could be a sole arbitrator or it could be a 3-panel arbitrator depending upon the arbitration clause in the contract. So once you send section 21 notice, that's the limitation point stops. As you file a suit, the limitation stops. In arbitration, once you send section 21 notice, the limitation stops. Then you have a liberty for 3 years for filing section 11 petition. Like after 21, you may have, certainly you have your limitation stopped by sending a section 21 notice. Then you have a 3 years period in your hand to move a section 11 petition. Here the crucial part is most of the time, if we have a counterclaim, people think that whenever he files a claim, I will file a counterclaim. So sometimes what happens, the other side may take more than 3 years getting an arbitration invoked. Your counterclaim can become time barred. So you have to be very cautious. If you have a counterclaim, see to it that counterclaim is either moved under 21 or you file a petition under section 11. If you wait for the other side to file the petition, and then you will have your turn for filing counter claim. Praveen Enterprise is one of those landmark judgments on the issue of counter claim, Supreme Court judgment, where a similar issue was arose. So if you are within time, the counter claim did not invoke a separate notice under 21. He can directly file a counter claim. But if you want to save your limitation, then you have to invoke 21 independently. So now the second stage comes, you file your claims, court is appointed under 11. Then the arbitrator will call for a preliminary meeting between the parties. So the arbitrator will, yeah, everybody is making a note what I'm saying. I'm audible very clearly.
You're audible, sir.
Yes, sir, we are.
So now we move ahead with the stage where the arbitrator is appointed. So once the arbitrator is appointed, he will fix a preliminary schedule. Schedule basically when you're going to file a statement of claim, counter claim, as you do in the trial court. You file a case, then you send a summons. In arbitration, there is no question of issuing summons. Parties on their own wish attend before the arbitrator. The arbitrator will fix the schedule. On the basis of schedule, parties have to file their claims, counter claim, whatever is there. Then the third stage comes with framing of issues, as it happens in the trial court. So there, I'm just trying to make everybody clear that arbitration is nothing new, where people think as if arbitration is something a very glamorous world and only very few people can, any trial lawyer can do arbitration. There is nothing, only thing there are technical issues are there as far as the appointment procedure is concerned. Then in between, if there is an arbitrator leaves the forum suddenly for some reason or the other, then you have to use section 12 for replacing an arbitrator. Normally people again file section 11, that is a wrong procedure. Once section 11, once it is filed, if you want to have the arbitrator replaced or change the arbitrator, you have to file under section 12 of the Arbitration Act. So once the directions are issued, parties complete the pleading. The stage comes as far as trial starts immediately. Once the issues are framed, parties are directed to file their evidence affidavit. Now here the very crucial part comes, how to prove the documents. So in arbitration, documents can be proved only by a person with a personal knowledge. And how do you say that a person have a personal knowledge? Can anybody just tell me what do you mean by personal knowledge?
The person who involved. The person who involves in that action.
No, when you see, if you tender a particular document, that document can be proved only by a person with a personal knowledge of the document. Who are the two people who would be having a personal knowledge?
Sir, the executant and the person who has perceived it directly.
That is one way. Assuming that person is not there in the organization, then that is a basic rule. The person who has signed the document or who has
Maybe the
written.
person might be having experience on that particular document.
No, not experience. There is nothing like experience in evidence law.
Knowledge.
Personal. See, the basic funda is either the author of the document or the person with a personal knowledge. If you have author, means the person who has written the document itself or who has signed the document is considered to be the author of the document. That is one person. But in case of a limited companies or corporate houses, the person who has done correspondence leaves the organization. That person is not traceable. So you have to look for another person who was there in the company that time. And that person would make, these are very crucial. That person will make a statement in the affidavit that I was aware when this document was issued to me. I am personally aware it was issued in consultation with me. So that way you can then pass on the burden of a personal knowledge if the author is not available. If the author of the document is available, he is one of the best witness for proving the document. In most of the cases, the authors are not available. So you can't have a hearsay evidence. You can't just say, from the record, person from the record can maximum prove the existence of the document, can't prove the contents. Contents can only be proved by a person who is personally aware of. Otherwise, in the cross, he will just ask two questions and a document will be struck out from the record. So the person should have a personal knowledge of that. That's the way you prove your documents. there are certain cases it happens that emails are exchanged between the companies. A lot of emails are exchanged between the parties. In those situations, assuming the person has exchanged the email, again has left the organization. And in most of the cases, you all have this CC, email marked to. Though if the email is marked to a particular person as CC, he can be a best witness. But assuming in some situation, even the email which are marked as CC, even that person is not available for a trial. So in that case, the government has to be a person who was available that time in the organization. You have to look for a person who has access to all these emails. So that person can make an government that I was in the organization, I was aware of this transactions taking place and had access to all these emails. Because you will not be able to prove, other side will ask whether that person is there in the CC or not to demolish your case that this person doesn't have a personal knowledge. So the document is not there in CC. So the person, the government should be that he is aware of everything and he has access also to all the emails which have been exchanged between the parties. This is the second way you prove a document where the emails are exchanged between the parties. Then you have the section 65B certificate and all that stuff, technical part. Before you file an evidence affidavit, there is always a stage for admission and denial of document. In CPC, if you see, there is a particular format which is given in which you have to give a notice to the other side, 24 hours notice for admitting the documents or denial of the document. That is not the case in case of arbitration. It's a simple notice can be sent to the other side for admission and denial of the document. Now here also admission and denial should not be taken lightly, because the entire further evidence will depend on your admissions and denials of your document. So in case of admission and denial, there are two columns normally that is created. There is existence of the document and contents of the document. And there's a reason behind creating these two columns, because there are certain documents where you can't dispute the existence, but you can certainly dispute the contents of the document. I will just deal with a situation where other side has written some letter to you and there are certain allegations against you. So those type of letters, you only admit the existence because you have received those letters, but to deny the contents of those documents. And certain document which you have neither received, so you deny both the existence and the contents of the document. Where you are not the author, where you are not concerned with the document, but other side wants to rely. So those documents you deny both the existence and contents of the document. The burden shifts on the person who wants to rely on the document where you are not party to it. That's his case, how he proves it. So admission and denial is a pre-stage before the other side files an evidence affidavit, because on the basis of admission and denial, he will then prove those documents which have been disputed by you, by the defendant, the existence and the contents both. So then he has to make accordingly relevant averments by getting the author into the box. He will get the documents exhibited. Then comes one more part is the secondary evidence. Now the normal rule is a secondary evidence. You have to take the leave of the court and all that stuff. That is not required. So whenever, what do you mean by secondary evidence? Anybody is aware of? What do you mean by secondary evidence?
So additional evidence
No,
already.
No, what I've told earlier was a primary evidence. What do you mean by secondary evidence?
It
Photocopies.
is not the original document, but the copy or the photocopy or the Xerox,
Yeah.
or we can say a duplicate.
So the original is not traceable, but original should be from your custody. You can't produce a secondary evidence of a document. There are two ways. There are two ways of proving a secondary evidence. One is the document which was there in your custody, which you have lost. And there is a document originally in the custody of the other side, but the other side doesn't want to bring the document on record. So you have to make the averment accordingly. So in the secondary evidence, when you're filing evidence affidavit itself, you can make the relevant amendments in your affidavit itself. There is no need to take the leave of the tribunal to file secondary evidence. So when you're filing evidence affidavit itself, you can make the relevant amendments. In case when the original document was in your custody, you say it was in my custody for some reason, fire or lost or employee misplaced it. That's why I'm filing a secondary evidence. In case when the document is there on the other side, you can say that so-and-so document original is in the custody of XYZ, and I'm producing the photocopy of the same. So you can, the tribunal will accordingly call upon. If it doesn't, then the document will be marked on the basis of adverse inference. This comes the stage as far as admission denial, primary evidence, secondary evidence. So your evidence affidavit would cover up this part. And once your evidence affidavit is filed, obviously the other side is bound to conduct the cross. So now the situation comes up, how your witness has to be trained. See, what is the golden rule of cross anybody is aware of? Anybody is aware of the golden rule of cross? There are two very fundamental golden rules on which the entire cross is conducted.
To demolish the opposite side witness.
No, that is a basic, like there's a general, there's a golden rule which has to be followed when you start the cross. What is the golden rule?
Just to first to take his introduction, what is he, how he is connected with that?
No, continue. That is not the golden rule. There are two golden rules. First golden rule is don't ask a question for which you don't know the answer. That is the biggest golden rule in cross. Because if you, with any question which you ask and whatever answer the witness gives is binding on you. So you can't take a risk of asking a question which you are not aware of the answer. So whatever answer witness gives, it can damage your case badly. Second golden rule is don't ask questions on the documents which are on record. The document will speak for itself. Normally, you see in the cross, people say, is it your signature? The document will speak on its own. There is no need to, because when you ask in cross any questions, the document will speak. Whatever answer witness give doesn't make any difference. So the judges don't like asking questions on a document, a printed document. And you should never ask any interpretation to the witness on the document. You can only ask the factual part, not his legal opinion from the witness. And the second golden rule is whatever is admitted by the witness, don't try to further cross him on those parts. Where not to cross is also very crucial. Cross doesn't mean you have to ask 100 questions, 200 questions. Cross has to be confined to your case which you want to prove. Sometimes the situation comes, I don't know anybody have faced, where witness lives in between. After 5 to 6 sessions, normally it happens in the corporate houses, where the employee suddenly says, I'm leaving the job and I'm not coming from the next day. So what is the law in that situation? Any of the advocates can answer that question?
So whosoever is joining on that particular position has to give
What
that.
happens of the trial which has already taken place? 200 questions have been asked and then the witness lives in between.
या सर तो उसमें एक एफिडेविट लगा करके जो उनके प्लेस पे आते हैं उनको ज्वाइन करवाया जाता है.
And what happens to the earlier examination?
The person who left is
which
bound
remained
to.
incomplete.
Sorry, sir.
the cross has remained incomplete. The witness is left in between. So what has to be done to his affidavit of evidence and cross?
या सर, तो जैसे मैंने एक अटेंड किया है, तो उसमें द विटनेस लेफ्ट इन बिटवीन, तो जो उनकी पोजीशन पे वहां आए थे उनको बुलाया गया था एक एफिडेविट के माध्यम
Obviously,
से.
the witness would be replaced. What about the cross which will happen, which is incomplete? It will remain on the record, or it has to be struck down from the record?
It will be on record.
उसको एडमिट करना पड़ेगा सर. सर जो नया बंदा आएगा सर, उसको वो एक एफिडेविट दे के पुराने वाले को अडॉप्ट करेगा, उसके साथ में एडमिट करेगा उसको.
But what about the questions cross which has remained incomplete? So over there, the issue is it depends upon the probative value, because that cross has remained incomplete. So when finally the matter has been decided, it has to be seen to what extent that cross has to be looked into. The entire cross cannot be relied upon. Even if it has been on record, the entire cross cannot be relied upon. The cross has to be seen the probative value, to what extent there are admissions in those cross, what are the issues which have been covered in those cross. Assuming the new witness comes and there are further controversies from the earlier cross, the entire cross has to be gone into. General rule is, if the witness doesn't turn up after filing examination in chief, then his affidavit is struck down from the record. But if the examination chief is filed and then the witness comes, there is one judgment of Balaji of Madras High Court that has gone on the conduct, where on the basis of conduct, even the entire cross was struck down. So though the witness was available, but subsequently didn't turn up, so other side filed an application that his cross has to be struck down, his conduct was not proper. So on the basis of conduct, the entire cross also can be struck down. So it's a very subjective and probative issue. It's not a very straightjacket formula. Obviously, the new witness can come in. That's not an issue. But the crucial part is, what about now? The witness who was there, for some reason, he lives in between. Court has the power to summon him and all that stuff. But in arbitrations, all those things doesn't happen. Normally, a trial court judges has the power to summon that witness. You can't live in between and all that stuff. But arbitration, nobody bothers to do all that stuff. If the witness goes, right. So if you read Balaji, you will get an answer to this. It's even on conduct, the entire record can be struck down. It's not compulsory. The cross has to remain on record. So I think so. Admission denial. Have you understood how the evidence affidavit has to be proved? Any questions on evidence part? But that is very crucial. Anybody has any questions of how the proving of document has to be looked into?
I take it, sir, if the employee has left it, so you take the evidence that yes, he was present at such and such time and this document was made in front of him. That's the gist of it. Admission of the evidence the employee has left, isn't it?
Yes, yes.
Basically, it is to be, as far as this thing you have mentioned, the personal knowledge that has to be proven by affidavit. That's what I want. Right.
But sometimes it happens that person who was the author or signature is not there in the organization. So then it becomes, governments are very crucial. You have to look for a person who was there in the organization at that relevant time. Normally what people do is they replace anybody without applying their mind. So the person will cross will ask one question, when did you join? And from the date of joining, they will say you don't have personal knowledge. Personal knowledge can be only of the person who was there in the company at that time when the document was executed.
No,
So assuming let's take a date, 1st December 2024, a document was executed. This person subsequently leaves. So the other person should be of the person who was in employment on 1st December 2024, not a person who was joined on 3rd March 2025. So he can maximum prove the existence that so and so lot of we have written, but not the contents. So the entire document will go waste.
No, the employee who leaves, his evidence by affidavit won't suffice that this.
Employee who leaves obviously will not come. So no
his evidence by affidavit that yes, it was in my personal knowledge, I made this document and
but if the employee is not available even to give evidence, then my whole part is the author is not available. in the company when the author is not available, who is the right person who can replace that particular?
Acha.
If
That
the
means
author is available, there is no issue at all. But in most of the cases, author is not available. He leaves the company. Matter evidence affidavit is filed after 2 years, after 3 years. Transaction has taken place in 2022. Evidence affidavit is filed in the 2024. The particular author, if available in 2024, it's very good. But most of the cases, the author is not available. People just blindly file affidavit of a person who has just recently joined the company. That is a fatal. You should always file an affidavit of a person who was available in 2022. Till date, he is available in the company.
Oh, I have got a question, sir. Supposedly, this issue is of 2022 and 24. I was an employee, I leave it. But the previous company approaches me that we require evidence that
Very
yes,
good.
this document, and if I give it, that is acceptable.
That is acceptable. But normally, none of the employees are available. So that's the biggest mistake that happens. People replace the evidence affidavit with a person who has just joined recently. So you have to be very cautious. Look for an employee who was available that time when the document was executed.
So that he can give it on evidence that yes, this document was.
I was present that time when this, all the government, I was present when this document was executed. So that becomes a personal knowledge. But a person who has joined subsequently can't make the such type of statement. He can maximum say, so when the document's existence would be admitted, contents would never be admitted. Once the contents are not proved, your case gets demolished.
What if any such person is not available who was
Then you have to
at
leave
that
the
time?
case. Then you have to leave the claim.
Okay.
Sir, suppose the author who retired, after retirement, he is ready to give witness. Is it acceptable?
He can come. Yeah. There's no bar on that.
Sir, is there any legal boundaries even after he retired, come and give witness?
No. Very good if he comes. But none of the companies would normally, unless the employee has been very loyal, but normally the companies would always have an issue that in cross he may damage, like he may be, if the author is willing to come, no issues at all.
But it is a practical problem. The people in the corporate and the person live in between. And a fresh affidavit is filed by the person who joined in that.
That's a mistake. You have to always look for a person at the relevant time who was there in your employment when the document was executed by an employee who has left the company.
But the point, it is a practical problem. In that case, only the language of the affidavit that matters.
Yes.
That
so the person who is already there in the employment, he can say on that relevant date, though he may not be an author, he may say, I had a personal knowledge. I was present when the document was executed. That shows he has a personal knowledge. But a person who has joined subsequently can't make this statement.
He can say that he had no knowledge of the content.
Yes. He can maximum say that, yes, when the document, he can maximum prove the existence of the document. He can't prove the contents.
Normally, you see that when the dispute arises, even in this case, that the agreement, which is basically a document of dispute, these are drawn much earlier than in between many people leave. So normally it is always the content of the documents it is usually written, a copy paste type.
So that's why a good cross-examiner will ask you 2 questions to the witness. When did you join? He will say, I joined on so and so date. The purpose is served of the cross-examiner that this person doesn't have a personal knowledge. So he is not able to prove the contents. He can maximum prove the existence. That so and so document was existing. So most of the bigger claims goes away because they are not able to get an employee who was not there at the relevant time when the transaction took place.
But the full citation of Balaji case?
Balaji's case of a second when the witness leaves. It's a very, you can write Balaji, the Madras High Court judgment on the issue of tracking down of the evidence. Balaji, I just give you. Any other questions on evidence part? Please feel free to ask.
Sir,
Sir, what is next if the
Sarvaswamy, Balaji versus Sarvaswamy. Balaji versus Sarvaswamy.
Sir, is the witness not bound to attend the arbitration proceeding? I mean, arbitrator under section 17 of the act has the same powers to summon a person, right, sir?
Section 17 is on the interim relief. You are in the wrong section, section 27.
Sorry, just a second, sir.
So 27, if you read the wordings,
Yes, sir.
see why the tribunal will take all those things. If you as a lawyer, it is power given to you, you make an application, the tribunal will pass order, and then if it doesn't turn up, then you can take the help of the High Court.
And like in case of a person having a personal knowledge and then also he leaves, like a witness
So
being
that's it's on. If you read the wordings, either the tribunal or the party who wants the witness to remain present.
right.
So when can we give additional documents, additional evidences or anything?
Additional evidence is you can give only when after filing you say that I have discovered just now a new document. So you have to take a leave. At the time when the evidence affidavit was filed, it was not there, or some new issues turns up at the time of process which was never ever pleaded or argued. So in re-examination, you can tender an additional document to prove that new issue which has turned up in the cross.
And its admissibility?
That the basic principles follows, admissibility and everything. So you just can't file, and in arbitration, section 18 speaks of ample opportunity given to all the parties. So nowadays, even if you file in between till your witness is not, cross-examination is not over, and if you find some new document, you can file an additional affidavit, which for some reason has remained to be either placed on record. But that document has to relate to the averment made. You can't come up with a new averment. For that, you have to amend your pleadings and then come up with the. So that additional document has to be related to the pleading which is already there on record. You can't come up with a new case. So in that case, then you have to either amend your statement of claim under 23 and then get your new case on record. Even that can be allowed at any stage subject to cost or whatever by the arbitrator.
Sir, what is the next available possibility? Even the knowledgeable person is not available.
Not available, then forget your case. Leave it.
Okay.
If you want your claim, you have to have a knowledge person on record. If not, then your claim will be struck down.
Yes, sir. The objection regarding this affidavit that he has no personal knowledge is to be raised at the time of cross itself or at the time of argument?
No, cross. He will prove in the cross.
Okay.
Then he will argue. In the cross, he will demolish first. Then in the argument, it will take, then it will argue. So in cross, he has to demolish that he doesn't, because the person would obviously write, I have a knowledge on the basis of record. That would be his basic averment in the affidavit with the person who joins subsequently. So in the cross, he will put up his case and then he will argue that this document have not been proved, contents have not been proved. This document cannot be taken into consideration, and hence the claim has to be dismissed. So there's no hearsay evidence is not allowed under the Indian Evidence Act. So the person who doesn't have a personal knowledge is called a hearsay evidence. Like, I heard from Y, I heard from Z. So the affidavit should never say that so-and-so person has heard from somebody. The affidavit of evidence should always say, I was there, and the right person would be the person at the relevant time when the transaction had taken place. No other person can make that statement. So, any other questions on evidence affidavit?
Sir, there is one question in the chat box by Mr. Nirmit. He says, sir, I have seen that in family dispute, that advocates tell that find someone who is not from your family as a witness. Does that person necessary under Evidence Act?
Understand one thing, evidence can be given by anybody. It's a business of the cross-examiner to demolish that this person doesn't have a personal knowledge of the case. Any person who has a personal knowledge can give evidence. Witness to the fact doesn't require authority.
See, it affects that it is an interested witness. evidence or is
Every witness is an interested witness. Why outside person would take interest in the matter? It's a duty of the cross-examiner to demolish his case.
particularly in the criminal law when they says that she is a close relations.
Yeah. So that's the job of cross-examiner. Whatever that is basically he's making a false statement. As far as the person is making a right statement, whoever his relation may be, doesn't make any difference.
Got it, sir.
Sir, is there any bar on list of witnesses as to how many we can?
No bar. You can have 10 witnesses, 15 witnesses.
And we need to submit it at the time of evidence affidavit?
Yes. In trial courts, normally they say you have to give a list. Even in arbitrations, they do, but nobody becomes so harsh as to it. But it is, the other side comes to know like how many witnesses you're going to file. So accordingly, you can decide whom to cross-examine. The evidence affidavit part, everybody's clear? For any other questions?
Sir, Renuji is asking if we want to prove the age of the accused and we have his handwritten diary, is that sufficient evidence?
Age of the accused, if you want to demolish, then you have to get the document from BMC record. You must have either in cross, you can ask that person that if assuming you feel that whatever age he has mentioned is wrong, you can ask for a document from that witness.
But on documents, I mean, there's some different age, and in his handwritten diary, there's a different age. So, can we
End of
prove
the day, the
that
BMC record would be the final document. Handwritten diary
the
may have
BMC
anything.
record has the incorrect age?
So then you present what is the correct age, then you argue out that correct age from the BMC record is so and so, and from the diary, it's the wrong age which is mentioned.
So, handwritten diary of the accused will not be of much use, is this?
No.
Okay.
The age normally comes in the case of a juvenile and all that stuff. Otherwise, every major witness, the laws are the same. Only the age factor comes when you face a juvenile and you want to protect that person from prosecution. So where the age factor comes. Otherwise, after reading criminal laws,
So basically, in the diary, he has written his age, correct age, with the date of birth.
The criminal law, the age doesn't make any difference. Once you're crossed 18, whatever age, it's a crime that is important, not your age.
No, got it. Just wanted to prove that, the accused person is lying it and things like that.
So there's another question in the chat box. Shivani wants to ask, in trial courts, can we add more witnesses later on to our list after submitting the list of witnesses before the court?
Yeah, before the other side submits their evidence affidavit, you have to. Once the other side starts to cross, then your chance is over.
Right, sir.
This section 319 CrPC. See, during the case, can't we just seek the...
Here I am on arbitration civil law.
Okay.
Criminal matters, Mr. You have to look for another thinker.
Sir, excuse me.
The parameters in civil and criminal are different.
I want to ask one simple question, sir, regarding submitting of photographs in the evidence. Nowadays, along with the pictures or the photographs which are submitted, we file normally an affidavit under Section 65B of Indian Evidence Act. But is it necessary to enclose the CD also along with that, or without CD it is okay? Only 65B.
It all depends. If nowadays, it all depends how do you produce the document. It either way of CD. Earlier, it used to be a film, like where the original, when they were a film. So we used to produce the negative of the film as well as the printout of that. So same way you produce a CD and the printout of the photograph before the, or you can play the CD, whichever way. So either it has to only prove from whose camera it was taken, and 65B has to be filed accordingly.
No, my question is, sir, that the 65B affidavit is submitted along with the photographs.
Yeah.
And because it is taken from the mobile, that is Android cell phone, so there is no negative available. At the same
So
time,
you can produce
with
a
the
CD.
with the photographers I have inquired, they are saying that CDs are not available now and they cannot produce or give CD. In that case, will it affect the case of the
Then the
person?
court will tell them to submit the mobile as an evidence. Wherever the photograph is there, that mobile has to be given in evidence then.
Yes, sir. Next point in this connection, instead of CD, can we store these photographs in pen drive and submit it?
Yeah, you can always.
Yes.
You have to only show the source from where, who has clicked, the author. Again, the photograph has to be by the person who has clicked it.
Yes, sir.
So
So
then he has to
finally,
make an averment that I have clicked through so and so mobile, and from this mobile I have downloaded to this pen drive. All those averment has to be there. There has to be a
yes,
proper
sir.
linkage.
Yes, sir. Those averments are there in the affidavit under 65B.
Yeah.
Now I am clarifying that in the event if the CD is not possible, I can use the pen drive for submitting the
Pen drive.
photograph.
These are very brothers and sisters. Either CD.
Excuse me, sir. The same content you can record in the chip that can be submitted.
Yeah, whichever way.
That is the only option.
Only thing is we have to show the author. Just remember this golden rule.
It will be accepted, sir. Already I have
Yes,
experience. The CD
Thank
content
you.
has been stored in a chip, then it has been submitted. It was accepted by the Honorable Court.
Thank you for your contribution, sir. Thank you so much.
Any other queries on evidence affidavit?
Sir, relating both the gentlemen, I am following on a legal error case, sir. Same 65B we gave, but the opposite lawyer during the cross examination, he asked for the negative. But the problem is the marriage was took place 1997. So that photographer, he doesn't have that negative anything. But we have the photos. We have submitted the photos to while marking the document. I have given also the CD. But while marking the document without negative, I can't take this as evidence. He denied. Coming 27th.
Because the original, understand again, the original was the negative in those days. So then
Yes,
we have
sir.
to then make out a case of secondary evidence where the negatives have gone. If we have pleaded secondary evidence, then the court will accordingly take a call.
Yes, sir.
Sir, we
Yes,
can
sir.
also
And
put it for.
another- 1 second, sir. Another related additional, sir. Can we take that photographer as an evidence and
Yes,
can
yes,
put him as an evidence, sir?
Yes.
Okay, sir. Thank you so much, sir.
Photograph, you can put it for expert evidence.
Okay. Thank you. Thank you so much.
No, wrong, mister. He would not be an expert evidence. Expert evidence is something different. Good, so there is something crucial part that comes up with the expert evidence. Those are the evidence normally either the arbitrator appoints in a cases where there is a software dispute where the arbitrator himself is not very much aware of a particular subject, so he will appoint an expert who will analyze, give his own opinion. On basis of that, the arbitrator will take a call. So expert evidence is totally different from your personal witness. Photographer can't be called an expert evidence. Expert is a third party who has no connection between yourself. He's a third party, gives an independent opinion on a particular issue. That's called an expert evidence. Now, in case of forgery, expert evidence is called upon. In case of a software dispute, even in case of forgery, there is no hard and fast rule to get an expert evidence. If the tribunal is sufficient enough to take care of that issue on its own, but Supreme Court says in case of forgery, the court should avoid giving their own opinion. It is better to have an expert on the issue.
Sir, one extension, excuse me, sir. In the event, if the litigant or our client, by chance and with good luck, if he has got both the things like negative also as well as positive also, then it will be very good, no?
Very good. Negative
So we
becomes
can
primary
produce.
evidence.
So we can produce negative as well as the positive
Yes, yes.
simultaneously.
Yes, yes.
So that will be, fulfilling. But in that case, whether 65B affidavit will be
65B is
required.
required only on this digital platform. Negative, you don't require 65B. So negative
So
word is
when,
gone. 65B is required because all this photograph is done on digital platform nowadays. That's why 65B comes in.
so for the purpose of negative 65B affidavit will not be required.
65B,
Thank you very much, sir.
negative itself becomes a primary evidence.
Thank you very much, sir.
I think we are through, sir. We can continue.
So after your evidence affidavit, everything is filed. Then the stage comes of cross. And after cross, arguments. In arguments, you should be very clear. When you're framing your argument, it should be framed issue-wise. Don't go ad hoc arguments. Your argument has to be very particular on a particular issue. Frame your argument, your relevant questions which you want to rely upon in a single page. So that when the judge or the arbitrator is writing an award, he doesn't have to run over the pages. He's aware from which part of the cross. So after that, because normally when the cross is conducted, they run into number of questions, hundreds of questions. But all the questions are scattered. So when you are doing a final argument, wherever the relevant questions are required for a particular issue, make a separate note of it at the time of argument. So it becomes easier for the judge when passing the order. He doesn't have to run here and there for the cross-examination.
I have a very small question, sir, here. I'm sorry at this time. Say, for example, already the court has decided about the issues, but they are not appealing to the litigant. So how to do the amendments as far as
They have
the
motion,
issues are
either notice
concerned?
of motion or in Bombay, it's interim application. You can always make an application that this issue need to be reframed.
So that should be done as early as
As
possible.
early as before the evidence starts.
Yes, sir. Yes. Thank you.
Your final argument should be very precise, very concise to every issue. Argue issue-wise, don't argue all the issues together. Pick up one issue, complete the entire argument on a particular issue, and then proceed for the second issue. And even while you are filing your written submission, even the written submission will always be on the issue-wise. It should not be a general written submission. That's as simple as that. Trial is nothing rocket science. Arbitration is nothing different from a trial.
What about the role of decided judgments while we are arguing, sir?
It is a very important role. So whatever judgments you want to rely on particular issue, quote those judgments at a relevant place.
So do you have appeal on that judgment, sir? Do you have appeal?
Appeal is always there under 37. 34, arbitration under 34, once the award is passed, section 34, you can file an appeal. And against the order of 34, you can file an appeal under section 37.
We are, I think we are done with the delivery and also with the questions. I think we can wrap it up unless somebody else has a question, although we have already taken the time that we were allotted out of sir's schedule. Okay. Sir, I think we are done with all the questions. On behalf of everybody, I'll thank you. First of all, it was a great session, sir. बहुत सारे ऐसे nuances होते हैं, ऐसे dimensions होते हैं चीजों के जो हम सोच नहीं पाते. And it only comes from somebody who has a lot of experience in one specific field. So thank you so much for the enlightenment, the kind of horizon that you've added. And I hope we can trouble you again very soon, if you allow us. So with that, we'll wrap it up with a hope कि आगे जाके we'll get many more sessions like this. Thank you so much, sir.
That is helpful to all.
course, sir. Thank you, everybody. Thanks for joining.
Patiently.
Much for
See
the
you all
organization.
sometime in court as an opponent sometime.
More
Right,
practical.
sir.
Very wise, sir. Thank you.
राघव जी रिकॉर्डिंग अवेलेबल होगी, मैंने लेट ज्वाइन किया था।
हाँ जी सर, रिकॉर्डिंग अवेलेबल होगी, 1-2 दिन में आ जाएगी।
ठीक ठीक, थैंक यू।
Thank you. Thank you.
All right.
Good afternoon.
Good afternoon, sir. Thank you so much.
Raghav ji, are you there?
Yes, sir.
Ji, the Tuesday session, today it will be available, sir. Tuesday, that first session. I didn't attend that.
Tuesday was a session on drafting.
Yes, that
Yeah.
video. It is available, sir.
The drafting session, yes, it is available already on the portal.
Okay, thank you so much.
Yes, yes. If there's any confusion about how to access it, just get in touch with Priyanka or get in touch with Rishita.
No problem, no problem. I can. No problem.
ठीक है, ठीक
Thank
है,
you.
ठीक है।
सर वो लिमिटेशन वाला
और
मिलेगा सर?
लिमिटेशन वाला सर, लिमिटेशन वाला भी आ जाएगा, YouTube पे आएगा, थोड़ा टाइम लगेगा।
अच्छा सर।
अभी कल क्योंकि मैंने 12 से 24 कवर किया था। Now there is 25 onwards that is to be covered, that I will cover on I think on Wednesday now.
सर YouTube का लिंक भेज सकते सर ग्रुप में?
हाँ, जब वो डल जाएगा तो मैं आपको भेज दूंगा। अभी तीनों लेक्चर जब हो जाएंगे तो मैं उसको कंपाइल करा के एक साथ YouTube पे डाल दूंगा, सो आप एक बार में देख लेना पूरा।
सर क्वेश्चन पूछा था सर मैंने इसमें ग्रुप में, सर वो उसमें लिमिटेशन वाला आपने पॉइंट बताया नहीं था सर।
लिमिटेशन वाला कौन सा पॉइंट नहीं बताया मैंने?
सर वो ग्रुप में क्वेश्चन डाला था सर एक केस का सर, नाबालिग अगर है और 1974 में उसका, और बाद में उसने 48 साल बाद में उसने उसको सेल किया है, 2024 में उसको वापस वो केस लेके आया सर, वो हो रहा सर।
मैं चेक कर लूंगा सर एक बार ग्रुप पे, या तो आप एक बार मुझे पर्सनल चैट पे भेज देना, आई विल आंसर दैट।
नहीं, आपने आंसर किया था सर, वो ए वाला कुछ भेजा था उन्होंने, फिर आपने आंसर किया था, फिर मैंने लिखा था उसमें लिमिटेशन ऐड नहीं है। एक नाबालिग जब बालिग हो जाता है और बालिग होने के 40 साल बाद में सर वो दावा करता है वापस कि मेरी प्रॉपर्टी थी ये, तो उसमें से 3 साल का लिमिटेशन बताया था एक केस में सर, वो केस का मैंने रेफरेंस भी भेजा उसमें।
मैं चेक कर लूंगा सर, एक बार मुझे पर्सनल पे भेज देना आप।
ओके सर, थैंक यू सर।
राइट सर, ठीक है जी। ऑल राइट, थैंक यू सो मच एवरीबॉडी।